In this video, we are going to talk about how to nominate someone as guardian of your children in your estate plan. I'm Attorney Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. First off, we need to talk about the two different types of guardianship. And one of them is the standard guardian under the will. So this is the guardian that if you pass away and the child's other parent has also passed away, this is the guardian that's going to raise them until they're 18. Georgia also has a second thing called standby guardian, and you can designate a person to short-term take care of your child if for some reason you are alive but incapacitated and unable to take care of them. So we've got two different types of guardianship, and if you've got minor children and you live in Georgia, I highly recommend both. And specifically, you may be thinking about a different person for each role, who's quick in an emergency, lives close, versus, who's the best long-term choice. But to designate an official long-term guardian, you need to do that in your will. And your will is going to distribute your assets and say who's in charge of your estate. But the other, huge clause is who should be guardian of my children in the case that I am gone. So I recommend backups. So let's list a guardian and let's list a backup guardian. And if you have more than one, go ahead and list a whole list of backup guardians. The other thing you're really going to want to consider when you're thinking about guardian is co-guardianship. So if I'm thinking, okay, I want to leave my child to my brother and his wife, do I just name my brother? Do I name both of them? And the way you solve that question is to think about, okay, something happens if my brother passes away. Is his wife still the person I want as guardian of my child? If the answer to that is yes, because you're very close and it makes sense, then you name them as co-guardians. That way, if something happens to one of them, the other is the guardian. If you realize that you really only would want them both as guardians if he were alive, you just name him as the guardian, and then if something happens to him, it moves on to the next guardian. So consider carefully co-guardianship versus just naming one person out of a couple. And then, like I said, I suggest doing a designation of standby guardianship as well. That is a separate document, and it names the person who can take care of your minor child for up to 120 days if you are mentally or physically incapable of taking care of them. If that mental or physical incapacity lasted longer than 120 days, then somebody has to go to court and get a long-term guardianship. And this, particular designation of standby guardian is not a long-term guardianship, but, it is very helpful in a short-term situation if you're going to recover and you just need someone who can make, medical decisions, talk to the school, do those sort of things on a short-term basis while you cannot. So these are the two ways that here in Georgia you nominate a guardian for your children in your estate plan. If you've got questions about this, realize you need to do some designations of guardians, either with a standby guardian or with a will, I would love to hear from you.